Good afternoon. Good afternoon. I think I put it that far apart. I think we're going to go ahead and start, although not everyone is here yet for the panel, but our consensus was that we would do that. Welcome to New Trends in Civil Law. My name is Louise Ellen Teitz, and I'm from the Hague Conference on Private International Law. And for those of you who don't know the Hague Conference, we are an intergovernmental organization, and we are almost 120 years old, and we are the preeminent institution, I suppose, in unifying, or one of them, private international law. We have 72 member countries, and almost 140 countries are either members or signatory to one of our many conventions. Some of you may be aware that Russia just recently acceded to the Hague Child Abduction Convention, which they acceded to in July of last year, and it went into effect October 1. So we are involved really in unifying the private international law rules, the rules on jurisdiction, judgments, and choice of law, rather than specifically the underlying substantive law. But we do have conventions that set up models for legal cooperation. So that is what we do. And I want to thank the organizers for inviting me here today. This is somewhat of an irony that a U.S.-trained common law expert and professor would be talking about civil law and codes because, of course, except for the state of Louisiana in the U.S., 49 states have common law, although we do have many codes in the context of, like, the Uniform Commercial Code, which most people are following in the U.S. We have a panel of 7 very distinguished speakers, which we're privileged to have, and each will speak for 5 to 7 minutes generally. I'll be the timekeeper. And then when everyone has spoken, I will pose some questions to the group generally, and then after that, we'll open the floor for questions from any of you. And I would ask that when you do ask a question, you indicate whether it's to the group generally or to one individual, and that you keep your interventions, comments relatively short, please, so everybody will get an opportunity. We will explore questions of trends in national civil law, regional. We'll also talk about perhaps the need for global instruments, and the panelists represent a broad range of perspectives and experience. And I'm going to introduce them all now, and then we'll go through, each one will speak after I've introduced everyone. First, we have Professor Yakovlev, who is a professor who's written on theory and law, civil law and justice. He's served as the Minister of Justice of the USSR. He was chairman of the Supreme Arbitration Court of the Russian Federation, and since 2005, he is the advisor to the president for the presidential administration. Mr. Gowan, who is not yet here, is the Minister of Justice of Poland. He holds a PhD and has written many books on the Catholic Church in Poland. He's written articles on philosophy and political science. He's co-founder and president of the European Joseph Tischner College, and in 2005 he was elected to the Senate, and he now serves as the Minister of Justice of Poland. Also missing at the moment is Mr. Demick, who has a distinguished and long career with the Dutch Ministry of Justice, including working as the Director of Police, the Director General for the Administration of the Judiciary, the Director General of International Affairs, and in 2002 he was appointed the Secretary General to the Ministry of Security and Justice of the Netherlands. Judge Navasilova is a judge with the Court of Arbitration. She has a Doctor of Juridical Science. She is a professor, an author of more than 200 articles, and has worked in the state arbitration of Russian Soviet Federal Social Republic, and then in 1991 was appointed as a judge of the Supreme Arbitration Court of the Russian Federation. Professor Markovsky is has had a distinguished career since 1980, working at the All-Union Scientific Research Institute of Soviet Law, the IZSP, and he served as deputy director, and he is now first deputy chairman of the board for the Research Center of Private Law under the Russian president, and he is the vice chairman of the Presidential Council of the Russian Federation on codifying and perfecting the civil law. Also, still not here, Professor Bergman, who is a board member of the Forum Petersburg and vice president for the International Affairs of the European University Business School in Wiesbaden. As early as 1974, Professor Bergman came for an internship to the USSR, and he has been involved in coordinating legal advice for the Federal Republic of Germany and Russia through the years, and participated in a number of legislative projects between Russia and Germany. And from 1997 to 2010, he also served as Deputy Secretary General of the German Academic Exchange Service, and as I mentioned, he is now Vice President for International Affairs of the European Union Business School in Wiesbaden. And finally, but clearly not least, Professor Hendley, who is a professor of law and also a professor of political science. She has a joint appointment at the University of Wisconsin, and she chaired the law schools, the University of Wisconsin Center for Russia, East Europe, and Central Asia. And she is an expert on Russian law and political science, author of numerous articles, and currently here on a senior for the year in Russia on a senior Fulbright fellowship. And so we'll start with Professor Yakovlev. The floor is yours.
You will have to keep track of the time. I have only 5 to 7 minutes. So, what can I say in 7 minutes? We have a list of questions which we are supposed to discuss. Have you seen that? The list of questions offered for our discussion. Have you seen that? Haven't you? If you don't mind, I will use that list for my speech, because we are very much interested in this meeting. Legal reform is underway in this country. The State Duma has already passed in its first reading the law on the changes to the civil code and these changes, these amendments are fairly serious. We've been working at that project for several years, and of course we were following the trends in the civil law worldwide and in the United Europe and outside of Europe. We consulted our foreign counterparts. We received quite a number of expert opinions on this change, and Professor Bergman was one of our consultants, but we decided it would be only right to speak a little bit more and longer on all those issues. Our work on civil law, does it fit with the modern trends of development of civil law in Europe? It looks like what we are doing matches the overall trends. These trends are fairly stable, but still they are veering. There are many new conditions arising, many new situations, and the law should be able to respond to that. For instance, the last economic crisis. How does it influence the law? And does it influence the law at all? I think it does. And I am absolutely sure that this financial crisis is the result of a lack of administrative and legal regulation. I do not want to say that you can prevent crisis with using law, but at least you can influence the consequences. You can influence the scope of those changes. The law might be powerless in mitigating the causes and results of the crisis, but I'm sure it is not so. The law should be flexible. The law should be used for this purpose as a power to prevent and might be to mitigate the trends which are alarming for us. Well, now a number of questions which we had. Does globalization retain the former significance? Or it has already gone away? Well, I remember how I suffered in my young days when I had to translate a book on private codification, on private law in England, from English into Russian. First, I didn't know English quite so well, and English law into the bargain. If it were not so different from the Russian law, it would have been easier for me to translate this book. However, after I translated that book and I passed the exam, I found a good Russian language translation by one of our professors who knew English much better than I did. Of course, there is a difference between an English law system and our system. There is no clear distinction between public law and private law. In Britain, everything is tied up or intertwined with the public law. Anglo-Saxon law gives us more freedom, more liberty when we enter civil relationships, but it also offers stricter sanctions for violation of the laws, of the legal standards. The continental law tends to prevent violations and torts. This is why there is so much significance attached to state registration, notariate. These are the means to provide legal safety for the participants of economic relations. And this is, of course, a way to prevent violations. Or might be to mitigate the punishment if there were violations around.
Therefore, of course, there are still differences between these systems. However, there is a lot of rapprochement between different systems, especially within the European Union, and a lot of cross-pollination. So we really need to take this into account, and we do take this into account. However, we shouldn't be trying to be holier than the Pope, and we shouldn't really put the cart before the horse here. We should really try to follow suit, the suit of Europe. We shouldn't be trying to jump ahead. The next question which was asked concerned merchant law. Commercial law should be codified separately. I don't think that Russia needs that. Russia has never had this practice, and I don't think it will go down this road. This is because Russia has a legislation system according to which civil legislation also covers and governs various commercial relations. This is the nature of our commercial code. It's an umbrella document which also encompasses private turnover, private relations, and this also includes commercial and trade relations. So there is no immediate need, given the current context, to develop commercial law as a separate branch. I don't think Kazakhstan has this need either, although for some reason they decided to develop what they call an economic code. I think that if they create this code, they will run into a lot of problems. They will face many more problems than they will resolve. Then there is also the question whether what is governed by civil legislation is now changing. Well, I don't think there is a principal change. However, some clarifications are being made. For instance, in our draft, we said that corporate relations are part of civil relations. They should be governed by civil law. Corporate relations should also be governed by the main basic part of the civil code, and I think this is beneficial because the general provisions of the civil code make up for loopholes in corporate law, and if there are any specific provisions in corporate law, they have the right to exist indeed. Nevertheless, our civil code is the core, at the heart of all civil legislation. So in our efforts, we tried to strengthen the role of that core by introducing into our civil code a greater number of general provisions that will put in sync our civil legislation with civil legislation elements in other laws, such as the law on commercial societies and so on and so forth. These specific laws will remain. However, the civil code will provide a common platform and a source of synchrony between these different specific laws. However, I don't think I can answer the question whether the EU is going to have a unified civil code. I think we have experts here who can answer that question. As far as precedents and the role of precedents in continental law is concerned, especially with regard to Russia, there is still an argument going on, but I don't think this is an argument in essence, this is more a formalistic or terminological argument. Some people say that, yes, we do have presidents and they may have some role, but what does it mean? That means that case law does contribute to the development of law. So some elements of case law do exist in the Russian system and the Russian practice, and I think the same goes for the European countries. What about corporate law? Is it part of civil legislation, or is it civil law, or is it a separate branch? I've talked about this, and the last question was, who must develop the new civil law? Well, different answers can be provided here. Again, the range of stakeholders is wide. The academia, bureaucrats, practicing lawyers, and so on and so forth. In my opinion, civil law or civil codes should be developed with important contributions from researchers. This is because we need a conceptual approach to these legislative developments, and without people who have in-depth knowledge of certain subjects, you will not be able to create legislation. However, researchers and scholars alone will never be able to create effective legislation. You also need practitioners. Our current civil code and the new amended civil code is the product of efforts which were exercised by these two groups of people mainly. On the one hand we had scholars, and on the other side we had practitioners, and by practitioners I mainly mean the judges who consider a lot of different cases, who are confronted with the realities of the Russian economy. They know the nature of disputes they have to deal with and the different violations that they face. So it's a blend of theory and practice in that sense. And I think that blend is prerequisite to creating effective legislation. And after that, there should also be a wide-ranging discussion among all the different stakeholders, including legal experts, bureaucrats, and so on and so forth. The developers of our civil code have worked for about 20 years, and their primary position is that of Russian citizens. They contribute mostly voluntarily, without any reward to this cause. They are not eligible to any grants, they are not receiving anything. These are just enthusiastic people who are committed to their cause, and I think we can be proud of them in this country. But of course it's always good to bring on board legal experts who are very knowledgeable about the practice, especially about foreign practice, people who work internationally. These people are indispensable indeed. However, it is important to make sure that their participation is not based on their own vested interests, but rather on the interests of society, of the citizens. The rights and freedoms of citizens are mainly, and their protection is mainly, the subject of civil legislation, I believe. Thank you very much.
Thank you very much. And you've answered most of the questions as well, which we're very appreciative of. Our next speaker is Mr. Deming, who I introduced before he arrived, but we've planned for each person to speak 5 to 7 minutes generally, and then after everyone has spoken, I'll ask some questions to the panel, and then we'll have some questions from the floor. So the floor is yours.
Thank you very much. I do have to apologize for being late, but I couldn't escape earlier from a ministerial luncheon that was very kindly offered us in a beautiful palace somewhere near here.
We apologize for starting.
Yeah, it was, no.
We had a consensus, so.
Yeah. No, anyway, no, but I hate being late for this kind of thing because I've missed all that went before. Well, trying to think of what I'd like to speak about here, I think that one of the themes that is not only dear to my own heart, but belongs to the priorities of my government, is that when we note that many states, not only EU member states, but other states as well, are currently revising their civil legislation, we'll have to give some thought to what should we in that case do and what should we avoid. And one of the things I think that we should avoid is that, while recognizing that of course it belongs to the sovereign right of any state to revise its legislation, the civil legislation being part of that, we should try and avoid that differences are getting bigger and the common ground is getting smaller. And that goes for Russia at the moment as well, because many law reforms in this country, the civil code is one of the issues. And I think that we should try to come to civil codes in the various countries that are now in the process of revising their laws, to a civil code that is in line with, well, the common denominator in European private law and international private law. Because only if we try to do that, we'll be able to offer a adequate level of legal protection to individuals and enterprises at home and abroad, especially for enterprises in these days of economical crisis. That any added security that when they do international business, they will encounter more or less the same sort of protection that they find in their own country, and that definitions of, well, whatever you come to in civil law, definitions in civil law in one country that look alike to definitions in another country are not completely differently interpreted. And so the Netherlands always has been an advocate of the greatest possible uniformity, of course coupled with respect for national sovereignty and legal traditions. But we advocate, and we have done so for many years already, uniformity on a voluntary basis. And when it's impossible, okay. But we do have to try, also in the application of international conventions, that they provide the legal certainty that they originally were intended to offer. I think there are some positive tendencies to be noted. For instance, although contract law at the moment differs from country to country, even within the European Union, I note with satisfaction that the European Union is working on several fronts to achieve greater uniformity in contract law. And as an example, a rather recent example, there's the optional common European sales law, so-called common frame of reference, proposed last year by the European Commission. Optional, by the way, means that parties to an international contract may opt to apply European sales law instead of, say, French or Dutch or German or whatever law. It's an option, it's not mandatory, but the fact that the option is available in itself already is of some importance. I do realize that the proposal has not been yet formally agreed to by the Council of the European Union or by the European Parliament, but the fact that it's there is already having an effect. And several member states already take it into account while reforming their own national civil codes. And that's an example where, you know, we try to come together even if we're not bound to do so. And as far as private international law is concerned, of course, it won't come as a surprise to you. My government firmly supports all the conventions of the Hague Conference on private international law, and we would strongly support every move that goes to further subscription to the conventions of the Hague Conference. The two projects that spring to mind in this respect, there's the project on choice of law in international contracts and a draft instrument that could provide a very useful framework. And last June, the working group of the Hague Conference adopted a draft of the Hague Principles on Choice of Law in International Commercial Contracts. That would be very helpful if as many countries as possible would support that. And secondly, there's a project on the access to foreign law in civil and commercial matters. And there's been a joint conference of the Hague Conference and the European Commission in Brussels last February. Those conclusions could prove to be of great interest to us all. So I think there are many possibilities to, without coming to all kinds of binding international conventions and which would be beautiful, but it takes tremendous lot of time. But both within the European Union and in the Hague Conference, there are at the moment many developments that are so interesting that I hope that we'll, on a voluntary basis already, achieve a lot that in the end could be achieved by binding instruments. Thank you.
Thank you. And I particularly thank you for the kind words about the Hague Conference, and the Dutch government has indeed been an amazing supporter of the conference and both financial and other ways has supported the conference. So thank you. Our next speaker is Judge Navasilova, whose name I'm sure I have mispronounced, and I apologize.
Доброе утро, уважаемые дамы и господа. Я хотела остановиться на некоторых вопросах, которые поставлены на...
To dwell on a number of issues now raised by this panel discussion. And I wanted to draw your attention to the fact that we have discussed mutual interference of various legal systems very much, because now, in the conditions of the global economy, we try to borrow features from various legal systems. we try to borrow certain structures and approaches from a different legal system. There is nothing strange and nothing new in that approach, because the global economy and the global business, they require a uniform solution, a uniform response to all those issues. And I'm specifically concerned about the relations of the business within the framework of the merchant law, and here we might have the closest we should have the closest relationship, because the uniform understanding will facilitate the business and it will facilitate trade. However, borrowing certain approaches or whole institutions and structures from a different legal system and the replanting of these systems into an alien soil, it reminds me, for instance, like if you tried to cut off an ear from a hare and try to plant it on a cat. I think that both will be unhappy, the cat and the hare. It is not a mechanical issue, this transfer of ideas and structures from one system to another. This work should be done differently. We should view first and foremost the fundamental systems, which has to be treated very carefully, and the introduction of the new elements into a legal system should go with utmost concern, so that not to harm any of the systems, not to let them rot from the inside. Speaking on a global scale about the difference between various legal systems, whether we should keep these systems intact or merge them. Yes, of course, we have to synchronize or harmonize the systems of merchant law, but it will be too far to speak about unification of these systems. Might be I'm mistaken, might be these problems are not unique Russian problems, but in Europe, for instance, centrifugal trends are really very strong, because in Europe nations, they do not want to merge, they do not want to lose their identity, and this is what we have to do. We don't have to try to make everybody the same. The situation is just like in every market, like it was said today in the plenary session. The competition of legal system. If we don't have any competition, we'll have a monopoly in the market, and this is what scares me. I am scared of the attempt, now very visible, to make everyone look at the situation in the same way. There is a certain pressure exerted by the Anglo-Saxon legal system onto the European legal system. And I think that formulation of these uniform rules, they should be based on mutual respect to the historic trends, to customs, and it should not, these efforts should not try to kill the identity, the self-identification of the nations which is manifest in their legal systems. And if we speak about harmonization of legal systems, might be we should not bring the family law or heritage law to a common denominator. These are very delicate areas, and I don't see any common grounds on which these systems could be made similar in every country. Speaking about the civil code, our civil code in Russia is among the youngest. And when we analyze the provisions of this code, we can make a very clear conclusion. The structure of the code has changed, not only because it is new and it has changed and it concerns substantial law, but when we start speaking about the contract law, we find quite a number of articles regulating various contracts. They have always existed in practice, and now the legislators think that these are the relations which should be regulated by the civil code. On the one hand, this is a positive factor, because if it is codified and it becomes a law, it is positive, it becomes a rule, and we have to support it. On the other hand, when we find ourselves in a very volatile environment, like in the market, in the banking services, you cannot cover everything by the law. You cannot provide a law for every and each kind of a situation. The legislator just won't be able to catch up with the changing market. The market is incessantly running ahead of the legislator's efforts. And whatever conclusions we make today, they will never be current for the environment built up tomorrow. This is when I become scared that when the laws and the civil code formulating a position on a certain issue tries to explain a situation which is still in motion, which is still fluctuating, which is not yet cast in granite, as our president said. So I think that on the one hand, the attempt to codify and harmonize everything is positive, but on the other hand, it is futile because we cannot count on the legislator being really well versed and in good time with all the innovations. These synchronizations should be performed in a selective way, picking up certain issues which can be synchronized, but not every issue deserves synchronization. And now about the new issue, that of the presidential law. And this is a new issue for me, and I wanted to voice my opinion on that. Speaking about the distinctions between various legal systems, Here, Mr. Yakovlev described the differences between the Anglo-Saxon and European law systems, but there is another thing also. The way how the law itself is formed. We know that law, continental law, is formulated by the legislators and it is interpreted by judges. And the judges should apply the law, interpret it. It is a written law and they are guided by the principles and provisions of the law. And speaking about the common law systems, the system itself was shaped by the courts themselves because there was no written law codified by the legislator. In this respect, without denying the judges the right to interpret the legal standards, we have to bear in mind that they can also kill that legal standard. The courts and judges, they should be able to form or to shape a uniform system which could be clear to every other judge, every other citizen. And the participants in commercial relations and the merchants coming to the court, they should know that there is a certain system within which they will be judged. So, speaking about the law of precedent, I must say that yes, we do have a law of precedent, but it is different from what they have in the Anglo-Saxon systems. Our judges, they can interpret the law, but they are not sources of legal rulings which contradict the overall system. This is where I see the challenge. When we try to institute a system of precedents in our legal system, it looks like when a teenager is shifting from one direction to another, we start to build together the practical experience, sometimes contrary to the written legal standard, because we just do not like this standard. But this is a dangerous path. Sometimes it is evident, sometimes it is not so obvious, and in the end we may receive a system when the legislators are on the one side and courts and judges are on the other side, and they do not cross. A very interesting question also was about who should develop the new civil legislation. I believe that the best results are when theoreticians and practical workers join their efforts, when the scholars and judges work together. This usually yields a very good result because it allows us to eliminate weaknesses before they become widespread, and it also enables us to eliminate really bad outcomes. I do not want to say anything bad about the officials. Usually they know quite well the realm where they are regulators. You cannot say that they are bad just because they are officials, but they should not be made fully responsible for the legislative work. It is dangerous. And the last thing I wanted to say about the corporate law and the regulations in that area. It looks dangerous when the corporate law is singled out and its specific features are underscored, and when the corporate relationships are separated from the civil law relationships. This is what I would like to have discussed. Is corporate law a separate thing, or is it a part of the general civil law relations? Does corporate law require a codification of its own? Do we want to have a code of corporate law? Then perhaps we should have a code of international private law, a code of heritage law, a code of family law. In my opinion, there is no need to single out the corporate law, attaching to it more significance than it deserves. I think that the provisions of the civil law are quite applicable, and an attempt to pull out certain provisions of the civil law and attach them to the corporate law will be destructive for the both. I think that all these legal norms and legal standards should find their way into the civil code. This is where I would like to finish.
Thank you very much. Our next speaker is Professor Markovsky.
Слышно, да? Первый.
Can you hear me? Issue number 1. The difference between the continental and Anglo-Saxon legal system will be in existence for a long time. At least it will be enough for our lifetime. We underestimate this distinction because usually we face it only applied to certain institutions, but it is a distinction not in the rules, but in the heads, in the judicial thinking. Once when I asked an American about the American law, he told me that the law, we view it differently. You interpret the law as it is written, while the American views it from the standpoint of the common law system. There are a number of aspects characterizing the relationship between the common law and continental law systems. Let's start with the problem of unification. Speaking about the global changes in the law systems in the 20th century, there were two outcomes. One was the proclamation of the priority of human rights and the international unification of the private law systems. And this was a long, tiresome, and even unsuccessful process. You will see that the stillborn conventions, which were not even ever applied, these were the conventions where these two systems of law could not be matched.
So these are stillborn conventions, and then there's another aspect, the reception aspects, how some law institutions are receptive to each other, and we have had some negative experience with this. In 1992, a presidential decree on trusts was signed, and the first words of it were, pending the enactment of the civil code, the following provisions shall apply, and the decree was in a language which was completely unintelligible to the Russian lawyers. So when we were formulating our civil code, we had to incorporate those traditions or take into account those provisions, but we could not. So as a result, we created a highly unreliable institution of trust. Another project that failed was the indemnity provision. We really failed with that also. So I think we should exercise extreme caution in such matters. I think success can only be achieved when there is a supranational body, as in the European Union, a body which is really pressuring for a reconciliation between different law systems. Whereas there will be a lot of dissatisfaction on the national lawyers, of course, who will be saying, how do we interpret, how do we apply these supranational provisions? Let me now talk about another question with regard to commercial law. Well, we live in Europe, we have two different approaches here, and it's not the end of the world. However, in terms of the current trends, I think the prevailing trend is towards a unified common civil code. Some countries such as Switzerland started down this road a long time ago. Italy started on this process relatively recently. The Netherlands joined even more recently. You may remember the Ministers of Justice of Czech Republic and Hungary, who presented at the previous law forum, and these countries had commercial provisions codified, and they were saying that we are ready to reject that in favor of a civil code only. I don't know what the status of those efforts is. However, I believe that the trend is clear. As far as the structure of the new civil codes is concerned, as well as how narrow and how broad the regulation should be, I think the overall trend is towards broadening coverage. If you take the commercial code of the Netherlands and if you see what they had in their civil and commercial trade code, they have broadened the scope. If you take our civil code, there is another example of broadening. You remember Part 4, how controversial it was when it was being drafted, how many lawyers were unhappy about it, how much debate there was. The US Embassy in Moscow almost officially warned us that this would preclude Russia from joining the WTO. There were very sharp, very important objections on the part of WIPO and so on and so forth. But that part was enacted. Of course, it requires revisions and amendments, but nobody currently disputes its rationale. So there is a broadening trend. How much broadening? Well, I think it's a matter of how comfortable it is and how it evolves. It also has to do with corporate law. There are two different approaches here. For instance, there is a joint stock society law in Germany. Then that's one example. Another example is the Netherlands, where their civil code covers these matters. I would say that it's a negative thing in Russia that joint stock companies are outside the civil code, because as a result we have two main laws on joint stock and limited liability societies. These two laws are not in harmony with each other. They looked very similar in the very beginning because Tatiana participated in the process of their drafting, so she knows they were very, very similar. But in the end, they diverged. at the initial stage, there were a lot of similarities, but one of these laws was complemented with 370 amendments in the recent years, whereas I think 3 times fewer amendments were introduced into the other law. As a result, they diverged. Again, for instance, managers' liability is treated differently with respect to these two different types of partnerships or corporations, and such differences abound between the two laws, even though half of the text is almost identical between the two laws. Perhaps it would be much easier to introduce several provisions into the civil code in order to unify and in order to overcome these differences. Is it possible to introduce a common civil code in the European Union? Well, let me tell you straight off, I don't think it is feasible, even though European Union is not my business really, but let me tell you this story. This story happened in 2004 when they celebrated the 200th anniversary of Napoleon's Code. There was a ceremonial conference in Strasbourg. Everybody said that the Napoleonic Code is a ray of light that will lead us towards a unified Europe, that we can see a unified civil code in the horizon. But then the Minister of Justice of France spoke, and he said, we'll really appreciate all the kind words about the Napoleonic Code, but we believe that as far as we can go, we cannot go farther than an optional framework for the entire European Union. Very similar words were said by the Minister of Justice of Germany. So far, we haven't heard any major developments within the European Union in terms of unifying the civil code. It seems to me that they're still there. The Lang team spent a lot of time working on this, but they haven't been able to make a difference. As far as the Eurasian cooperation is concerned, I think the situation is somewhat better there. You see, very early on, in the beginning of the 1990s, a model civil code was created for the CIS countries. It was used as a point of departure for these countries to develop civil codes of their own, and as a result, these civil codes are very similar in structure and the nature of their provisions. This is an unprecedented project, which I think is unheard of around the world. Even despite the Napoleonic Code, I think even the Napoleonic Code did not have such a powerful impact as this model civil code for the CIS countries. Of course, then we saw a process of divergence, and there are still some differences between these codes. I don't think we can safely ignore these differences today and try to create a common CIS civil code. Of course, the point of departure would be to at least establish some civil law fundamentals for these countries that would be general enough not to go into too much details. And I also wanted to say something in response to Ludmila's words in terms of what she spoke about banking operations and transactions. She said that the market is moving forward fast. Yes, the market is evolving fast, but think back to 2008, we were really running, and look what happened to the financial services market. And look at where the US law and European law is going these days, when they're trying to sort of restrict this galloping speed at which the market develops. I don't think it's a good thing when we see the market going forward very fast, ignoring the legislation. There should be a certain framework imposed on this development process. Let me jump forward straight to the last question now, skipping one question. I've covered corporate law already, but the question about who should be developing civil legislation. Well, I think I can brag about a thing or two with respect to my track record, because I have been in the business of developing laws for some 50 years. Again, there was one gap, some gap in my civil law career when I went into maritime law, international maritime law. I believe there are two groups of people who can develop civil legislation maintaining an objective attitude. These are judges on the one hand and scholars on the other. As for the other categories of developers, even if they are international organizations, there will be often vested interests involved, even though although implicitly. For instance, some organizations represent businesses more than there are international organizations that represent ship owners to a greater extent. For instance, when they talk about commercial law, whereas judges and scholars are in a position to maintain a relatively objective attitude. I would also like to add to something that was said today about Russia and the Conference on International Private Law. Russia only recently acceded the conference, that's true, but let us not forget that Russia was one of the founders of this conference very early on when the conference was born.
Thank you for reminding us, in fact, that Russia was one of the early participants in the ad hoc meetings of the Hague Conference and was involved, one of the founding countries. Next, Professor Bergman.
Thank you very much. Is it on? Is it on? It is off now. Mic, please. Okay, thank you very much. I'm very glad to be here and to see you all. I would like to highlight some of the things that were said this morning already. And of course, I would like to talk about corporate law, but a lot of different opinions have been expressed. I would like to express my opinion. Mr. Yakovlev, I highly appreciate the fact that civil codification and economic codification will never be unified, neither in Europe nor in any other group of countries. Perhaps it might be possible that several countries would adopt common principles, general principles, but they cannot have a common piece of legislation simply because different judges will be interpreting differently. This is one of the reasons why Europe does not have a common court for civil disputes. And a lot here depends on the national legislation. I believe if we were to try to unify it, it would take us about 20 years of controversy. I think what is really important is to have a set of common principles developed, and after that each country can use them when formulating their legislation. The same goes for Russia. I cannot recommend that you translate a foreign law and enact it. Yes, you can translate it just to study it, but after that you will need to have a lengthy series of workshops to discuss. It's the same in Germany. Very few people in Germany understand their civil code because it contains very specific language, very specific wording. So you need to look at the different interpretations of the civil code. If you look at the current German civil code, and if you look at the case law and the different comments provided by the courts, you will see a lot of departures from the law in the interpretations. So, in my opinion, civil legislation development is important. Of course, we can do it in different ways, together with colleagues together with our Russian colleagues, in the same way as with our European colleagues. We could carry out a discussion process, but at the end of the day, it will be up to you. It is a Russian law we're talking about. You don't need any German practices. There can be a joint discussion, but there can be no joint legislation. I think the US Secretary of Justice said today very rightly that we are partners, not patrons. So I think this is the way to resolve these issues. And I simply understand that there is a lot of controversy involved here. Some of the other questions. I believe that the trend to formulate things very abstractly, for instance, with respect to corporate law provisions, to make umbrella provisions for all types of businesses, ranging from 5-employee businesses and all the way to tens of thousands of employees, is a suboptimal solution. Currently, both in civil law and in public law in Germany, there is a lot of debate going on. It is very good that in our public law especially we have common legislation for all administrative decisions. We understand very well that if you are building an airport, a railway terminal, and so, or any other project, it's a totally different matter than a decision made, for instance, by a law enforcement authority. And of course, it should be interpreted and applied through different law, on the basis of different laws and through different bodies. So I think discussions like these when people say that large enterprises require special legislation to regulate their economic activities, I think for large enterprises it may be justified. They may require being governed by separate instruments, and their position may be different in contrast to small and medium-sized enterprises. There are different articles applying in Germany to enterprises up to 5, up to 100 employees, and enterprises with more than 100 employees. I think this can be achieved through one law or several laws. It doesn't really matter. You can have a civil code, you can have a specific commercial code. What really matters is the results. You may achieve the same result within one piece of legislation. You can achieve the same through several pieces of legislation. But at the end of the day, what really matters is what result, what outcome you achieve. The third point, judicial competition. Mr. Ivanov, the chair of the Higher Arbitration Court, spoke eloquently about this today. Yes, I do believe that the first step would be to publish anonymous rulings. But those rulings need to be published because this strengthens the intellectual discipline of the judges. If a judge knows that a ruling will not be published, there is a lot of room for manipulation. But if they know that their decision will be published, they will make sure that they stay within the scope of the law. Because once a ruling is published, it will be evaluated by the legal community and by other judges as well. So publication of rulings is one thing. Another thing which is really desirable is joint seminars. Together with the German government, we run workshops for judges from Germany and Russia and other countries, and there is a lot of mutual learning happening there. For instance, at one of the recent workshops, German and Russian judges were able to consider one case, and they explained to each other their reasoning. It was a mutual learning experience. So from that standpoint, I think competition is very important between judges because it's also a learning process. Today, in the morning, a lot was said about publishing various instruments, laws,
Правда. Но
In my opinion, everything was very true. However, we don't have any shortage of publications. I don't know about your country, but I think there is quite a lot published in this country, and in my country also we have lots of publications. I don't know. I think that there are opposition groups which feel that they are not involved in the judgment process. And this is the issue. What part does the civil society play in judicial process? How they are involved via internet or might be via newer forms of communication. How does the civil society gets involved in the judicial process? In Germany, only through organizations, no other way. But now, through the Stuttgart railway station, we have found that this is really a problem. We have to think how we can integrate the civil society into the legislative process. And now about the corporate law in Germany. In my opinion, court judgments in the corporate law agree that the courts do not heed, and they do not value in any way inside the decisions taken by big corporations. For them, these decisions within corporations have no value at all. They are for transparency. The judicial community says that if there are secret owners, non-disclosed founders of companies, this doesn't mean anything. If one founder or investor invests into a company, then the minimum contribution just does not count. And this is according to Article 5 of the German Code. The Supreme Court of Germany ruled that the legal firms cannot be limited companies. The lawyers cannot get together in this form of corporations. Also, the legislators changed the laws on bankruptcy for legal entities. For us, it is very important that the company shouldn't be razed to the ground as a result of the bankruptcy. In the company, there may be divisions which operate properly and are in quite a good shape. And we think that they should remain like this. And this influences directly the social climate. And this means that there should be amendments to the laws on corporations and the laws on bankruptcy. The European Court has passed several judgments on taxes, if these taxes can be paid in more than one state. Many foreign investors, and some of them from Russia, they invest money in German companies. And we have to be very serious about the laws governing such investments. Why a company should have its legal address in the UK, operate in Germany, and collect money from those operations in Russia? This should be done. This law should be amended, but the changes are imminent. Germany will sort out what money it wants and what money it does not. We do not want somebody to come with a suitcase full of bills, for instance from Greece or from Russia or from other countries, and invest the money into German companies. We would like to know whose money came, who the money belongs to, why they were brought here, because we would not want bad money in our country. Somebody has got to start. If we trying to say that the market is the same in all cases, it will mean only that there will be better control over the company, over its management, and over other legal matters associated. And the last thing I wanted to say, there was an interesting thing. We know that quite a lot of these amendments may be an additional agreement between the partners, which will be in force only in the partner relations and have no effect for the third party. These agreements should not contradict the contracts or articles of associations or rights of any third person. Such agreements exist between the partners, but internal agreements regulating inside procedures, they may be applicable, but for principal issues, we cannot apply internal documents. They have to be published. Thank you for your attention.
Thank you very much. And finally, Professor Hendley.
So the disadvantage of being the last speaker is that, one, a lot of the good ideas have been taken already, and that you guys are tired. So I'll try to energize the room, and then our moderator can get us going again with some general questions and bring in some of your wisdom. I'm sure there's a great deal of wisdom in the room here. Like Professor Teitz, I'm an American, so I was not raised in a system that's a code system, but even so, I think it's important to remember that in the United States, we do have a number of areas of law that are very much controlled by codes. And one of those areas is economic law. We have the Uniform Commercial Code. And I think that if you had asked someone in the middle of the 20th century whether that was possible or not, whether it was possible for all 49 states, Louisiana would just leave on the side of the road, but for the other 49 states to come to an agreement about a single commercial law, most people would have said that's impossible. So when I listen to Professor Makovsky and others talk about the impossibility of a common European law, I just wonder what that will look like in 50 or 60 years, whether or not we might be able to come to more of an agreement on that. Now, I think that one of the interesting things about the Uniform Commercial Code is the way it came into being. And that's one of our themes, is who should promulgate these laws. And there's been a general consensus among the speakers here that it should be scholars and judges. And it's probably no accident that most of us up here are either scholars or judges, right? So we like ourselves. But in fact, our Uniform Commercial Code, the key player in that was a man named Carl Llewellyn, who was a scholar. But the genius of that code was that it wasn't simply a collection of abstract ideas. Instead, it was a reflection of the best practices of commercial law at the time. So it was an effort, and this builds on something that Professor Makovsky said, not simply to bring in ideas that someone in the room thinks are good, like trust or something like that, but instead to really try to figure out how business was operating and to take out the stuff that maybe was self-interested and to leave in place the very best practices. And I think that's and so in doing that, you bring in certainly scholars, certainly judges, but also you have to have, it seems to me, a reciprocal process that integrates businessmen and in whatever field you're talking about law. And one of the ways that we do this in the United States is through a very elaborate system of hearings, where we go out and we seek out practice. And this goes to the point that Professor Bergman was making about the importance of bringing in civil society. And we've certainly found that when you do that, then there comes to be a sense of ownership within society of the law, and therefore when it is passed, it isn't their law, it's our law, and there's a greater willingness perhaps to obey it. One other aspect of our Uniform Commercial Code that I think is worth mentioning is that it combines in a very ingenious way the predictability and stability that businessmen like and need, and this was commented on at great length in the plenary this morning, with a great deal of flexibility. And the flexibility comes from a recognition that within different spheres of industry or business, there are going to be different practices. And this is something that was alluded to earlier in terms of the role of big companies or small companies and perhaps needing different rules for them. Through concepts like trade usage or course of dealing, you're able to recognize that perhaps the timber industry is slightly different than the agricultural industry. And some of you may listen to me and think, well, all that's about precedent. And it really isn't about precedent, because in a way, each case stands on its own, because each case is dealing with the specifics of what those parties want. And in fact, when I teach this area of law, one of the things that we talk at great length about is the idea of what does it say on paper? So the paper deal, the contract itself, and then the real deal of what actually happened. And this gets into the intent of the parties. And I think one thing that's true is that the American system is much more open to testimony and information about the intent of the parties than certainly what I've observed in Russia, and this may be common in Germany and other civil law countries as well. And that may be part of the difference between the two systems. But it does create a perverse incentive that favors people, and favors people who have great lawyers and understand how to put together airtight contracts that may or may not reflect what actually happened in the deal. And I know when I spent time here doing research in the 90s, when there were so many barter deals that often were not reflected in the paperwork, that oftentimes when these cases would come to the arbitrage court, there would be a sense that what was being enforced wasn't really what anyone intended, but simply what happened to be on the paper. And I'm not sure that's what anyone intended to have happen. Now, as to the question of precedent, I think that Professor Yakovlev made an excellent point when he said that this may be more a question of terminology than of substance. And I think that certainly from an ideological and theoretical point of view, the idea of precedent is sort of anathema in a civil law system. But at the same time, I've been struck, as I've spent the last year sitting in your court, in the courts in Russia, mostly in the Justice of the Peace courts and in the first instance arbitrage courts. And I think this train may have left the station without maybe us realizing it, because the existence now of the websites that publish the decisions of courts has led to a kind of bottom-up practice of litigants bringing to the attention of judges. Now, it's not like our system where you would have a brief where you incorporate all this, but they will often bring to the attention of judges decisions in analogous cases, decisions of the appellate court, if that's the next level up, to sort of make them aware of this judicial practice. And I just wonder, in 10 or 20 years, is that going to look very different? Is it going to be a little bit more systematized? I certainly understand that there are massive differences between the way in which precedent works in an Anglo-American or common law system, and I think to make that change would require so many deeply profound changes, not just within the judicial system, but also within the system of legal education, in terms of how we teach people about law and how you learn to find these cases. And although certainly computerized databases make that a lot easier. But I think that these websites have had not only the positive contribution that Professor Bergman mentioned in terms of disciplining judges as they recognize that other people are going to be reading their decisions, but have also had this very interesting effect, almost in a civil society kind of way, of making people who go to court aware of what how similar decisions, or at least have the ability to be aware of how similar decisions have been made in the past, and try to, in some way, hold judges accountable. And I think perhaps that's a positive development. We can see what other people think. So I think the one other thing I wanted to mention is that we've been, in terms of talking about how laws get drafted, there's a lot of discussion of judicial practice and of bringing in judges and of bringing in scholars. But again, to go back to the point I made earlier about talking to businessmen, one of the things that kind of approach leaves out are the cases that don't get to court. And certainly in the business area, the vast majority of disputes never get to court. That's more true in the United States than in Russia. And so it's very important to understand, and so the law in that sense operates as a set of kind of default rules that in a way discourage or at least make people aware of what's going to happen when they get to court. And so I think it's important to understand the extent to which, or the way in which, the rules in the codes will either incentivize or discourage litigation, and then think about and keep, that's an ongoing kind of inquiry, right? And one of the other things that Professor Teitz and I were discussing this earlier is that when we have a code, we have an ongoing process of working groups that incorporate both practice and scholars and judges that continue to think about how we might change it in response to the constantly evolving situation in which we find ourselves, and I think even more so now than ever before due to technology and other challenges that we face in implementing law. So thank you very much, and I look forward to your questions.
Thank you. We've covered a lot of ground already, looking at the questions of whether codes should be national, possibly can they be regional, should they be separate areas of law such as commercial or all unified, and who should make the law, and we've heard totally different viewpoints on some of these. But I thought I might start by asking a question that we've touched on parts of already, which I guess reflects in some respect my perspective from the Hague Conference. Yes. Would you like to comment on something somebody else said? We'll do that first then. Go ahead, Professor Bergman. Sorry.
Thank you. Я хочу только сказать, что я не очень люблю.
Thank you. I just wanted to say that I don't really want to see anybody here saying that, for instance, our law, our legislation is more open than other legislations. I think that the Russian colleagues can see for themselves which systems work, contain elements which work better for them. We could compare different systems here, and perhaps I could also levy a lot of criticism at the US legal system as well.
Said that it was more open. I simply just commented on the difference between the two systems and the implications of that. So I apologize if anyone took offense, because that was not my intent.
I think that we all look at the law from our own perspective, but one of my questions, I guess, that I wanted to ask is whether there is increasing convergence, whether members of the panel feel that there is, in fact, less of a distinction between common law, between Roman law, between traditional civil law distinctions, or whether these distinctions continue in the overall legal systems. And I thought perhaps some people would have comments.
Well, I think that there is necessarily a certain convergence already, if only because growing internationalization, not only of trade, but also of the legal professions, has that as a consequence. The number of times that in Dutch courts foreign legislation or foreign precedent is cited just to interpret a situation or to explain why parties have behaved as they did behave. Because, let's face it, most court cases are as much about the law as about what happened in practice and how can we establish what the intention of the parties was before we come to interpret it, what is the applicable law. But you see, certainly in commercial cases, there is conversions in the way judges look, and any professional will look upon certain aspects of the law in their own country. But the systemic differences remain. And you will always come to a point where a judge, although he might like to change his opinion, feels so bound by a long-standing national interpretation of the law that he doesn't feel free. So in the end, legislators or international legislators or all those of us who work on the Hague Conference should come up with solutions that define the common ground. And that could be very helpful, very helpful. But as to your question, yes, there's certainly in the past 30, 40 years a certain convergence.
Yes, in fact, Judge Novosilova touched a little bit on that earlier, and you might want to elaborate.
I would like to draw your attention to the fact that despite the differences, sometimes deeply ingrained differences between legislations of different countries, whenever we discuss specific cases, specific problems with judges from other countries, despite these regulatory and legal differences, judges will often arrive at the same outcome, the same decision, albeit through different mechanisms. So we cannot say, of course, that one country has good legislation and another country has bad legislation. They are all built on the same principles. They're just expressed in different ways. For instance, can you think of a national legal system that encourages theft or rewards theft? Is there any system that says that if a contract is signed, it doesn't mean anything? But of course, there will be differences between various national legal systems. These differences exist. However, the underlying approaches and the fundamentals, they are the same. So, of course, we can offer different explanations of how this or that solution, how this or that decision was arrived at. However, when we discuss cases, we usually, at the end of the day, arrive at the same conclusions. Yes, there are differences, but especially in the field of commercial law, these differences are not really major. They do not really impact courts' behavior and courts' case law. So I would say that with respect to specific situations, concrete scenarios or cases, very often courts of different countries would rule on such cases in the same way. Yes, there is definitely a convergence process underway. You remember this morning we had a very interesting presentation reflecting on how conventions are developed, the Vienna Convention. I believe that the Vienna Convention provided a basis for this kind of convergence. When we were in the process of developing our civil code, we effectively incorporated a lot of provisions from that Vienna Convention into our civil legislation, whereas the Vienna Convention in itself is a result of a convergence process, is a result of a rapprochement process, a compromise. So convergence is underway. My colleague here made reference to specific cases, and yes, indeed, we've had a lot of discussion and exchange with our colleagues from arbitration courts from other countries. We focused on specific cases, specific situations, and we've never had any principal differences, especially with the German judges of the German Supreme Court. Sometimes we would even arrange it so that they would take a specific case, a real-life case, a real-life dispute, for instance, a contract between a Russian and a German side, and then we would take some of our case law, some of the cases that we had ruled on, and then we would exchange our views on each case, and we ruled together on the cases. Let me tell you that our decisions were 100% identical, which is a testimony to the fact that at this point differences, even though they do exist, when you stress differences, you are usually exaggerating. It's another thing that you cannot really ignore a lot of things or go too far here when, for instance, you take one legal institution, and the case in point of this was when some of our lawmakers hastily enacted the law on economic partnerships, and I think the other one was on investment partnerships, right? No, it was never enacted. Sorry, that one was never enacted. When we inquired about these investment partnerships, these kinds of corporations with our English colleagues, it turned out that the authors, the drafters of that Russian bill had transplanted a lot from the Anglo-Saxon system, but what they transplanted was just the contract, the agreement part of it, whereas the English law is much wider. The English law cannot operate simply by governing, by regulating these agreements. There is an additional system of regulation in place that they have, which encompasses licensed activities also, and the authors of the Russian law were silent completely on licensing. Then they also have, as part of their system, insurance, and there was nothing on insurance in the Russian law. In the English law, they also had very high liability of the managing partner. Again, this was omitted in the Russian law. So it's not just a mere institution that they have. It's a part of a larger system. You cannot mechanically transplant one element to your soil without incorporating all of it. So I believe that you cannot afford to be that unprofessional. I don't even know how to explain that lack of professionalism, whether it's just ignorance or whether it's the result of certain vested interests that were pursued in that particular case. So I think this is to be avoided. You cannot mechanically take one institution, one element out of a system without introducing all the other supporting elements that provide for effective operation of that institution. So we should avoid mistakes of this kind. My colleague, Professor Makovsky, has already made reference to that when he gave the example of the trust law. The trust law was enacted, but it never worked. It simply faded away, sort of.
I might mention in the Hague Conference, in our work, we have in the family law area a process which we have. It's called the Malta process, which has been an attempt to get judges together from different legal systems, including those who are, the Malta process looks at those where the countries have legal systems that have Sharia basis or Sharia influence systems. And we found that if you give them the same actual facts and hypotheticals, ultimately they end up with the same result. They come to the same kind of treatment through a different process. But again, where the focus is on the individual facts, judges often get to the same result. I think I will open it up for questions. If you would just state your name first, and if it's directed at one panelist or at the whole panel.
Thank you. Alexei Zverev,
I'm Alexei Zverev, European Bank for Reconstruction and Development. My question concerns the role of precedents in the history of Russian law. Olympia Dioffe wrote in great detail that during the first codification that took place in Russia, Russia was able, not only in theory but in practice, to implement case law. This was in an era when Speransky's commission operated, and they came up with that codification. So this is my question. Do you think that we might in practice be able to introduce precedents into our legal system? And if that is feasible, then do you think it is necessary for the benefit of Russia's development and economic development? Again, I understand this is an open question, open to all of you, but perhaps this is a question addressed to Mr. Ms. Novoselov, Ms. Handley, then Mr. Makovsky and Mr. Yakovlev. Well, I think I need to be very sincere here, because I'm not aware that Russia in the times of Speransky had case law in its pure form. At least I've never come across such examples. That's my first point. My second point, when we talk about precedents and the role of courts as creators of law, we sometimes confuse two things. I think that traditionally the court has been extremely important in shaping law in Russia, but this is not done through a mechanism of precedents. A different process usually happens when a law is when the court will essentially create legal norms. If you look at the different court panel decisions on the high level, even back in the Soviet times, you will see in those rulings a lot of legal norms. Again, they are not 100% legal norms. Sometimes they interpret laws, sometimes they try to adjust laws, but sometimes they will introduce completely novel principles. I don't know about the current codification, but the 1960s codification I did analyze, and I analyzed inheritance law in the Soviet Civil Code, and I tried to see how many principles, how many provisions in that civil law were directly derived from the rulings of the Supreme Court. And it turned out that those norms, those provisions were first generated by the courts. As far as pure precedents are concerned, well, I'm not sure. I'm not sure if it's going to work for our system, because for precedents to work, you need to have, let's say, more skills in your judiciary system. You need to have a system which is more advanced. Unfortunately, this is not the case with our courts, especially common jurisdiction courts. They are overburdened with cases, and they are suffering from a number of different constraints. If you allow me, I would like to also say a couple of words in response to some of the speakers. For instance, with regard to the commercial code, every time when somebody says in Russia that we do not need a codification for commercial law, people say, but they do have it in the US. How come we don't have it? But we need to understand the situation here, and I'm afraid not everybody in this room understands this. The UCC in the US appeared not because of some troubles, actually, because the founding fathers of the American Constitution delegated nearly all competences with regard to private law to the states. So nothing was left for the federal center. This is a situation where they do not have federal laws as such in the US. They have state laws. And if my memory serves me right, one of the important creators of that law was a Russian by birth, Ms. Melnikova, who was the Secretary General of the Institute of Private Law. So that story also has some Russian roots. That code also has Russian roots. And it was a very difficult process of drafting the code. First, initially they had individual laws for sale and purchase and other aspects. Then it was created as a big law, and then New York State and the state of California said no to that draft. So they had to make amendments to adjust it to the requirements of those two states. After that, it gained acceptance. And even in the States, they call it the Bankers Code. It only covers a limited number of institutions in the US.
There is a very positive moment concerning this code and related legislation. There is an agency that monitors everything, including UCC, which is ever-changing. There is a commission of commissioners, an interstate agency, and each state delegates two representatives to this commission. And every state is involved in putting together these uniform laws which are later passed through the legislative assemblies of all the states. And this is what we lack here, and it would be very useful. Another thing, when we speak about commercial legislation, it concerns entrepreneurs, their law professional, they are all operating at their risk, but the entrepreneurs are really very different. And today, the distinction between huge businesses and small businesses, it is very clearly felt. In Britain, in the UK, for instance, if you have BP on one side and a filling station on the other side, everything will be okay. With us, in the similar situation, small business will end up with his arms wrangled.
During the Soviet system and continuing through today, there are things that very much operate like precedent, the guiding explanations, the постановления, and those kinds of things. I do think that and this is what I was trying to say before about the role of the websites and the existence of these opinions online. I guess I don't agree that it has to be a top-down process. It seems to me that now that these opinions are being published, it's now become more of an interactive process where judges have to take account, and even if they say that I don't have to obey that decision, they at least maybe have to explain to the parties why they didn't do it, and that maybe that is useful. Although I do think that, to go back to the question of the chair, it seems to me that on this question of convergence, one of the things that's most interesting is that if we look at Anglo-American systems, that we see more legislation than we would have seen 100 years ago. And if we look at civil law systems, with the proliferation of constitutional courts at a very minimum, we see the at least beginning embrace of the role of judicial decisions as a source of law. Neither one is ever going to embrace the other completely. So, and let me say a few words about the UCC. I hope I was not understood as saying that this is a model law or that everyone should have the UCC. I totally don't think that. I was simply commenting on the process by which the UCC was adopted, and I don't agree with Professor Makovsky's history that it was adopted out of a bad a period in our history. That I think that this, and this may come from my training as a sociologist of law, but I think it's always useful to understand how things are actually operating, and then to make a decision about whether or not you want the law to reflect that, or whether you want to push it in a new direction. But I think that it's useful to explore what people are actually doing in one area of law or another. And I think that's what Llewellyn and his wife, Sonia Melnikov, tried to do, and what the commissioners continue to try to do. Now, one thing that it's very important to understand about American politics, and I don't want to give you a lesson here on American politics, but you cannot just tell the states what to do. And he alluded to this with the fact that California and New York said no to this. But passing any sort of change to the Uniform Commercial Code is, extremely difficult. And so it's not, again, this goes to the question of being top-down or bottom-up. It's something where you have to build the support within these 50 state legislatures or 49 state legislatures, which is a completely different understanding of federalism than exists here. Not bad, not good, just different. And that really is what I was trying to say about the issue of paper law versus paper deals versus real deals. There are a lot of disadvantages to the way in which the U.S. system handles it. It takes a lot more time, it's much more inefficient, it perhaps doesn't give as great predictability as the way it's done in Russia and other places. But if your goal is to try to figure out what the parties wanted to do, and I think that's what Llewellyn and Melnikov were trying to do with the Uniform Commercial Code, they were trying to say, we want to respect the intent of the parties. And that was their goal. It may not be the goal of the Russian Civil Code. And so that's what they were trying to accomplish. So my goal was never to suggest that we have that the Uniform Commercial Code is the right answer for everyone. Absolutely not. So.
This gentleman, let me let the panelists respond first, and then we'll take a question for the audience. Just a minute. Let the panelists respond. Yes, Judge.
Ну, это продолжение, так сказать, дискуссии о прецеденте.
Now, following in regard to the discussion of precedent system, there is a convergence between the two systems. In the countries where presidential law was preeminent, now the statutory law also gains respect. However, in the continental Europe, the trend is in the different direction. The judicial practice begins playing a bigger part. Historically, of course, we do not rely on precedents when the law was produced by the courts. With us, law is produced by the legislators, and it is impossible with us for the courts to produce laws. It is anti-constitutional, and it is contradictory to the principle of the division of powers. The judiciary, they should not replace legislative power. However, it cannot be avoided. The courts cannot but take an active part in the development of the legal system, because without this, justice is absolutely impossible. And this is in our dogma, in our constitution. We have judicial interpretation, which can be à la lettre, it can be restrictive, and it can be freer. Legislation always is behind the life, while the courts can keep up with the life in its development. This means that the courts are instrumental in tying up legislation to the actual situation and environment. There is also a principle of analogy. If there is no law, the court can apply a similar law, and if there is And also there is a principle of similarity of the law, that a law may be applied on the basis of similar legal principles. So here, when the courts interpret legal norms according to their understanding, they develop the legislation. And that brings us closer to the countries of the common law. And we are, of course, there are more similarities than dissimilarities between us. When I meet judges from the US, UK, I find that very often our positions agree. There are more common, more uniform in the law, in the legislation, than there are differences. I wanted to draw the attention of the Russian audience to the following. The draft civil code is published. And if you analyze certain provisions of this civil code, you can see that quite a lot of issues are formulated in such a way that it poses quite a lot of difficult issues for the courts. For instance, there is a provision that a compensation or remuneration can be demanded in case of violations or other breaches of the law. For instance, a participant in a company, a stockholder, can demand a compensation. There are many new methods of legal defense. For instance, damages can be recovered without any detailed description of the damages and their evaluation. This is Article 33, paragraph 5. So the judge should rely on the principles of fairness and responsibility determining the amount of compensation or remuneration. Just imagine that a judge will have to determine the amount of remuneration out of his own experience. Might be it's not right. The judges should apply the law, and applying the law they created, but not to such extent. This is what I wanted to say, to make the role of courts more important, and it should be even more important than today. I feel scared that laws, even written laws, without proper enforcement, it will be empty, it will be nothing. And this is what scares me. There will be no legal norms, legal standards, legal methods of defense, and I'm afraid that this will require even higher investment, quite a lot of additional funds because we needed different skills. We need different qualifications of the judges. Even now, our courts are overloaded. And I think that if we want the law to operate efficiently, to increase financing of the legal system, many times over, I see what is going on now, how the courts are working. They just won't be able to live up to the new requirements. Our colleagues from the state of Delaware, they told us how their courts were operating. And they say that they offer high-quality services because they discuss the cases of the first instance no longer than in 6 months' time. With us it is 2 months, and our judges could not understand why it takes so long for the Delaware judges to settle the dispute in a 6 months' time. Just imagine whether it is possible to settle the dispute studying all the instances, all the testimony, all the clues, all the proof, and give a decision if you have at the same time 17 cases like that on your hands. We work just like a production line where everything moves like on a conveyor belt. And all the time we hear complaints and reprimands. Might be fair. I wouldn't want to say that we have the best system. Of course, there are disadvantages with us and our own faults, but the criticism leveled at the courts, the criticism that the courts do not understand quite a lot of sophisticated elements now existing in trade relations, but we just do not have enough time to apply all that to our cases. And the new draft code, for instance, offers a provision of affiliated character, and it gives a list and says that this list is not exhaustive because the judges can decide for themselves who is to be considered affiliated and who is not to be considered as such. And there will be no confusion on that. And speaking about the legal practice, I'm sorry, I wanted to speak about justice, but it is discussed in a different room. Of course, the uniformity of practice is a great thing because it provides for the predictability of the court decision. When we come with a case to a court, we should receive a logical decision. But we should not treat judges as people always following instructions. Maybe it is national trait of the Russians. They are really very emotional. They want to bring everything to the logical end. And when we try to put together uniform legal practice, we forget that when a judge takes a decision, he is seeing a situation, and knowing about precedents, he can say that yes, there were precedents, but they do not cover this actual situation, this fact. And he will have then to substantiate his decision without being afraid of the cancellation of his decision. This takes time and money.
Thank you. Can I, Professor Bergman, I believe, wanted to respond? Yes? And
we have very little time left, but I just wanted to say that perhaps one problem can be solved here, namely the problem of overburdening judges with courts. We have several years of experience in Germany of mediating medical disputes. This is a panel of two doctors and two judges. So over the last 20 years, there has been a 30% decrease in the caseload on courts with respect to this category of disputes. Perhaps this is one solution for Russia.
Actually, there is a roundtable on mediation, I believe. One of the roundtables is on mediation. So I think I'll take a question from the audience, another one.
Yes, I'm Professor Ramberg from Stockholm, Sweden. And I was very happy to hear that a lot of provisions from the Vienna Convention or the 1980 Convention on International Sale of Goods were taken into the new Russian civil legislation. And it was rightly said that this is a very important convergence of different views from different nations. And I think that the convergence actually has proceeded further since 1980 into the UNIDROIT principles of international commercial contracts from 94, now as revised in the version of 2010. And my question is this, will those provisions be taken into account when legislating in Russia? May I say that the convergence in the UNIDROIT principles, which are frequently, although not a statutory law, not a convention, merely principles, they are taken into account in courts all over the world and in arbitration awards. And may I also add that thanks to the late Professor Alan Farnsworth in the United States, there is a lot of input into the UNIDROIT principles from the Uniform Commercial Code. So if those provisions are taken into account, you will in fact get an enormous convergence, because the ambit of the principles is far, far wider than the ambit of the sales convention.
Yes.
Yes, I knew Professor Farnsworth very well, because back in the 1980s, together with some US scholars, we started a very ambitious project, namely the agreement on the Soviet and US legal systems. This work was only getting started back then. We were published one book, which was authored by Professor Farnsworth. It came out in Russian and in English, but then the project was discontinued due to the drastic changes in my country when Gorbachev came to power, and we simply could not really keep up with the pace of changes that were occurring around us. So we stopped that work. But yes, indeed, the authors of that time, under that project, certainly had those principles in mind, and they identified those principles that can be incorporated into the civil code. This can be done, this should be done, and some of it has been done.
And I think this brings us back to, in fact, one of the questions about whether global instruments are possible and the role of non-binding law, which Mr. Demick made reference earlier to the new work at the Hague Conference on principles for the applicable law to be applied in commercial contracts, which my colleague Marta Pertigas, who is sitting in the second row, is in charge in that project, which will actually have a special commission this November. So the project will move on, but it I think raises the question, because for the Hague Conference, it is non-binding law, which is a new, conceivably a new step for us. And I think it raises the question about, when we talk about both convergence and about broader regional and global codes or instruments, whether in fact we should be looking or may end up looking at non-binding instruments and principles, and whether that may be the best hope for finding consensus among the different legal systems.
Well, I think it's all a question of where can you achieve the best result within a limited period of time. And I think that on a global scale, the non-binding way is by far the most promising. That being said, I think that within, for instance, an institutionalized group of nations like the European Union, we will probably take some more steps in the direction of binding rules. But that should never bring us from the path to trying to achieve globally more uniformity by non-binding rules. So that, I think that's a very promising way.
When I said that, in my view, international unification is one of the major milestones in the development of international law, when I said that, I meant that we're creating not just a unified set of rules for specific types of relations, but that these principles will also impact certain national legislations even where they do not directly imply it. If you take, for instance, the Geneva Conventions of Bexmel and Chekhov, they contain a standardized set of rules, and whether or not you need to introduce that law in your country, which we did in 1936. But when the Vienna Convention, as far as the Vienna Convention is concerned on the sale of goods, it does not require to be incorporated into national legislation because of its scope of application. However, nevertheless, because that convention addresses quite successfully a number of issues, we voluntarily transferred some of those principles into our civil code. In particular, the quality assurances, for instance, because we thought it would be simply unreasonable to be governed by two sets of principles. To have one set of principles for home use and to have another set of principles based on the Vienna Convention for foreign trade. So we believe that this was a good achievement for us. However, international commercial contracts, that's another example. When as we are now revising the civil code, what we are effectively doing is that we're taking a number of norms, up to a dozen different norms, and we are basing our legal provisions on those UNIDROIT principles. However, we are mindful of the fact that those principles have a different purpose. They are mainly geared to the parties to a contract. They want the parties to structure their relations based on those principles. So these are not norms or principles that can be enacted by states so as to give them a general nature.
Question from the audience. There's a gentleman who has a microphone back there.
Thank you, Madam Chair. My question concerns the unified code of the European Union. However, before I ask my question, I want to make a brief remark. I would like to thank Professor Makovsky, who reminded us that it's not about acceding to Russia joining the Hague Conference, but rather re-establishing itself as a participant, because very early on Russia was a member and was a participant, and since we're in St. Petersburg, let's remind you also, Fedor Martens, a well-known Russian legal expert from St. Petersburg University, was the chair of 4 consecutive committees in the beginning of that process. So let us remember about this historical heritage. Let us remember that we're not just joining the Hague Conference, but we are establishing ourselves as a member, especially that the Ministry of Justice has now formulated the task of joining those instruments where Russia was not a part, of which Russia was not a part. But here's my question. It concerns the common unified code. When the European economic space was being established, they said that they did not aim to unify the law, that they would be rather pragmatic about it and only unify whenever it is necessary. But because they were creating a common economic space, they started by unifying in the field of international private law and then made some active inroads into civil law. Professor Markovsky said just now that in his opinion a unified civil code is not possible, not only for the EU but also for the CIS countries. So my question is to the German participants. What is Germany's view on this? Are you just as pessimistic as Mr. Markovsky, or do you see some light at the end of the tunnel? Oh, yes, you're right, and I'm quite pessimistic. I would say that it's more important to have not formalized laws, but a common understanding of civil legislation principles. However, a unified civil code for the entire European Union, the next question we should ask then is, are we going to have a unified, a common civil court for the EU to interpret that code? I don't think this is feasible, because I think judges from Holland, Germany and other countries will provide significantly different interpretations to that law. And I think that today the conference of the Ministers of Justice of the EU is not prepared to consider adopting such a law. Well, I understand that you also made reference to the European-Asian Cooperation, Eurasian Cooperation. You know, as part of Eurosec, one of the principles there is to introduce common legislation. We're not looking at a common civil code. However, there is a possibility and there is a discussion around possibly introducing common fundamental principles for civil legislation. There was a meeting of the ministers of justice of these countries not a long time ago, and on the 20th of May there will be another meeting here. One of the things that the ministers are discussing is the possibility of adopting the fundamentals of civil legislation, which would be unified. And more than that, we already have a small draft of that act. However, this is still pending, this is still being discussed and looked into. As a first step, it may be possible for several countries to adopt some fundamental principles together, and this would be an important step forward, because in most of the states which formed after the breakup of the Soviet Union, the civil codes were drafted and enacted following a single model. You remember we talked about the 1990s model civil code for the CIS countries. So their civil legislation is very much in sync. But now, as they are updating their civil legislation, it would be really preferable if the fundamental principles were developed in order to preserve this convergence and the similarity.
Question, I think we have time for one more.
Thank you. My name is Jan ter Stegen from the Dutch Ministry of Security and Justice. I have one small reaction to the issue about the European Civil Code, which is not a civil code but a toolbox for member states and the community to use whenever they feel fit. I think we should not forget that for commercial law, a big chunk of commercial law is already European law. The whole competition law is European, and judges all over Europe do apply this piece of European law without any major problem. And I think in the future it will be very interesting to see how the dynamics develop of the toolbox and the voluntary pieces of law that are in that. Member states can also decide to apply it on their internal legal relations. It is possible for the parties in international European relations to use that toolbox. And I think that over time it will be difficult for member states not to allow their citizens the use of the products which are in the toolbox. So over time, maybe we might end up in an American system, but it may take some more decades. And then I have a question. Several of you have spoken about precedent, and I think many people thought that there was a certain convergence. I think the Netherlands, being a civil law country, does give the judge some leeway, some room for maneuver, using the old Roman concept of bona fides, and he uses that to also include precedents in his cases. And for that, appeal is very important, because appeal allows you the possibility to look at this case at a higher level. I was wondering, I have been informed that in Russia there is a reform underway to introduce appeal in civil and penal cases in a novel way. I was wondering whether you think that that might also give a possibility to use precedent and to improve the efficiency of justice. I would be interested to hear from the Russian members of the jury whether they think that's something. Thank you.
Oh yes, I believe we are moving in that direction. The draft law on amendments to the Civil Code envisions as a general principle to introduce the principle of due diligence. Again, there are objections to this from people who say that this gives too much freedom to judges and that judges will be likely to act more arbitrarily. So there are some concerns. However, we believe that this principle should be put in place, the principle of due diligence, and perhaps the court interpretation of this concept will be especially important here. I do believe that our courts can use that and will be able to cope with that. Of course, it will take some time to develop case law, but this is the way that judges all over the world are going. Yes, indeed, this principle, the answer is yes to your question.
Questions. Well, this one and then the woman in the back who's been waiting will be our last one.
Дмитрий Гелеб, Промсвязьбанк. Вот у меня вопрос. Мы обсуждали...
Dmitry Gilep from Promsvestbank. We discussed the object of the civil law, that it is expanded these days. In the Russian law, everybody acknowledged that the Russian law is of a dispositive character, that everything is allowed except for what is forbidden. But it looks like in our everyday life, the judicial practice interprets it differently, that everything is forbidden if not allowed explicitly. For instance, this trend was evident when the High Arbitration Court decided on Commission on loan agreements. Even if there was an agreement between the parties that there is interest and commission should be paid for the loan agreement. But the courts disagree. They say that commission is not provided for in the law. And this means that the approach to the legislation is of an imperative character. Might be civil law becomes more imperative, and even the parties agreeing to something, they have less and less room for free movement. Well, let's not discuss this specific case. I know about that. For me, it is much more important what the civil regulation is founded on. You started with saying that everything is allowed if not directly or explicitly prohibited by the law. But then everybody agreed that this doesn't concern public law, but might be it will work for the private law. No, it won't, because if you take any kind of legal relations founded on absolute rights, the regulation there can be exercised only via imperative relations, imperative norms and standards of the law. Speaking about other norms of civil law, I mean the transport code, for instance, the interpretation of these norms and standards is again founded not on a dispositive but on an imperative character. If you do not find in the norm an explicit expression of its dispositive character, you should still imply that it is dispositive. All the standards, if not imperative, should be dispositive. But in this case, we should take an inventory of all norms of contract law. This means that the method of dispositive regulation is not excluded, whether it is the right to exercise rights or the right to establish rules, it will be quite a different thing. However, if a dispositive standard exists, does it mean that the parties can divert from that standard wherever they would like to? In fact, it boils down to a supposition that, for instance, the legislator has written something and the parties can do whatever they like. There are lots of things, lots of emergencies when these things just cannot apply. When the legislator introduces a norm or a standard of a dispositive character, he implies that he has produced a very fair norm or standard. And as soon as you diverge from it, this means that you diverge from justice, however erroneous or might be wrong that might be. So I think you should treat every standard in this case, every dispositive standard, with a grain of salt. And there was also a mention that the civil law becomes more and more imperative. Just compare the Soviet time civil law and the existing civil code. It is a gigantic step towards the dispositive character of the legal norms. Try to compare the general part in the existing code and in the draft code, and the number of dispositive standards, dispositive norms, has grown very considerably.
I believe, on the new civil code. Time for one very quick question? Yes. And then I know everybody the translators probably, the interpreters have had a long session.
Рассказывала Наталья Юрьевна, Санкт-Петербург. Мой вопрос очень короткий. Он не столь глобален.
Natalia Raskazova, St. Petersburg. I have a very brief question. It's not of a global character. Might be I would like to address Lyudmila Alexandrovna and other experts as well. The first article of the Civil Code is planned to be amended, adding corporate relations to the sum total of the Civil Code. Do we have to review our relation to the subjects of the law. Even already we have a certain confusion between legal entities, their management bodies. For instance, when the law tells us about the consent of a legal entity, it might be consent of a management or consent of a meeting of shareholders. So how do we then distinguish between citizens, organizations, assemblies of citizens, and so on? I think this question can be discussed on Saturday in more detail, but we do not want to expand the list of the subjects of the law. The purpose was different. When we describe the relations within a society, we have to deal with different objects of law or subjects of law. When we discuss relationships within a company, the situation is completely different. I would like to draw attention to one very important aspect. Many provisions of the Civil Code, they were put there with a view to regular human relationships. They didn't take into account, for instance, relationships between the consumers. At that time, no one even was ready to discuss the consumers' rights. How we could apply the provision that all parties to the contract are equal, because as soon as we come to the relations with the consumers, these relations are somewhat outside of the civil code, of the civil rights, and they are more they belong more to the public law than to the civil law. And it look so the idea is that there should be better delineation between separate spheres of law.
And I hope you will join me in showing our panelists how much we enjoyed the session, and join me in a round of applause. And thank you also to the interpreters for staying with us for the long time.